securities attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today, I'm going to talk about how depositing penny stocks with brokers has become increasingly difficult, particularly in light of the charges brought by the SEC against E-Trade Securities. This is segment 1 of a two-part securities LawCast. On October 9, the SEC filed an enforcement action against E-Trade Securities and E-Trade Capital Markets for selling billions of unregistered penny stocks for 3 customers. The SEC found that the firm processed the sales on behalf of 3 customers while ignoring red flags that the offerings were being conducted in violation of the federal securities laws, in that the shares were neither registered nor was there an available exemption from registration. E-Trade Securities and E-Trade Capital Markets settled the enforcement proceedings by agreeing to pay a total of $2.5 million in disgorgement and penalties. Also on October 9, the SEC issued a risk alert and FAQ to remind broker-dealers of their obligations related to unregistered transactions on behalf of their customers and ensuring such transactions are being conducted in accordance with securities laws. The SEC press release on the matter quoted a director of the SEC's Division of Enforcement, which sums up their position. The director said, "Broker-dealers serve an important gatekeeping function that helps prevent microcap fraud by taking measures to ensure that unregistered shares don't reach the market if the registration rules aren't being followed. Many billions of unregistered shares pass through gates that E-Trade should have closed, and we will hold firms accountable when improper trading occurs on their watch." So what happened? First, a little background. The securities laws, and in particular Section 5 of the Securities Act, generally require all offers and sales of securities to be registered with the SEC unless those offers and sales qualify for an exemption. The burden of proof that a valid exemption exists rests with the person claiming the exemption. That is, once it is established that there was no registration filed or in effect at the time of the sale, the burden to prove that there was a valid exemption shifts to the seller of the securities. Scienter, which is a legal word for intent, is not required to establish a Section 5 violation. Section 4A4 of the Securities Act provides an exemption for broker-dealers when executing customers' unregistered sales of securities if, after reasonable inquiry, and that is key, reasonable inquiry, the broker-dealer is not aware of any circumstances indicating that the customer would be violating the registration requirements of Section 5. The recent FAQ issued by the SEC addresses the broker-dealer obligations when relying on Section 4A4. Section 4A4 is not in and of itself an exemption from registration. Section 4A4 is a rule that allows broker-dealers to process the sale of unregistered securities where there is a valid exemption from such registration. And it is the broker-dealer's responsibility to be aware of the requirements necessary to establish an exemption and from the registration requirements, and to be reasonably certain that such an exemption is available. In other words, when selling unregistered securities using a brokerage account, there are layers of obligations to ensure compliance with the laws and that a valid exemption exists. First, the seller has a burden of ensuring that they have a valid exemption to rely on in the sale. And second, the brokerage firm has an additional and separate obligation to ensure that a valid exemption also exists. The actual registration exemption that people rely on when selling unregistered securities is usually Section 4A1. And so Section 4A4 would require that the broker-dealer make reasonable inquiry and be reasonably certain that Section 4A1 is available and that it applies. Section 4A1 is a registration exemption for transactions by any person other than an issuer, underwriter, or dealer. It is pretty easy to be certain that a seller is not an issuer or a dealer, but it requires much more analysis to be sure that they are not an underwriter. To keep it simple, an issuer is the public company. And without getting sidetracked on the complexities of who could be considered a dealer, for simplicity, for today's webcast, a broker-dealer is an entity that is buying and selling securities for their customer accounts. The term underwriter is defined in the Securities Act to include any person who has purchased from an issuer with a view to, or offers or sells for an issuer in connection with the distribution of any security, or participates or has a direct or indirect participation in the distribution of securities. For purposes of this definition, the issuer includes affiliates of the issuer. Most commonly, reliance on Section 4A1 includes compliance with Rule 144, which is a safe harbor under Section 4A1, though compliance with Section 4A1 can be separately established. To summarize where we are so far, 1, the sale of securities must always be either registered or there must be an available exemption from registration to rely upon. 2, it is the person relying on the exemption that has the burden of establishing and ensuring that a valid exemption exists. 3, when selling through a brokerage account, the brokerage firm has an independent responsibility under Section 4A4 to ensure that a valid exemption exists for the sale. 4, the brokerage firm has a duty to make reasonable inquiry in meeting its obligations to ensure that a valid exemption exists. And finally, 5, generally the underlying exemption that the seller is relying on and that the brokerage firm must confirm is Section 4A1, which again is the exemption for any person other than an issuer, underwriter, or dealer. In the second segment of this LawCast, I will explain the broker's responsibilities, including what constitutes reasonable inquiry and what red flags broker-dealers should look out for when effectuating sales for a customer. I'm securities attorney Laura Anthony, founding partner of Legal in Compliance. Should you have any questions about the information covered today in this LawCast or any other corporate or securities matters, please feel free to contact me directly. Inquiries of a technical nature are always encouraged.